This is the Law Matters. Welcome. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to protect yourself, your family, and your business. We've been providing information and resources that will help you decide whether or not you, in fact, need to contact a lawyer. Perhaps we'll help you determine whether or not you can handle some issues yourself. If you do need additional outside counsel, you'll be better prepared, and hopefully so will the professional who you select. The goal, of course, is to save you time, energy, money, and hopefully to help you achieve the best possible results. We once again want to welcome and thank the Bazar law firm in East Providence, who continue to help us with their insights and perspectives on the topics that we'll tackle. Attorneys Jacqueline Grasso and David Bazar from the law firm continue to help us. Today we want to welcome David Bazar.
Thank you.
Thanks, David. So today, the issue is work contracts. They're in the news. There are so many issues that are so close to home and so many that affect you. Non-compete agreements affect you whether you happen to be a top-notch manager or whether you end up being even a lower wage earner. Sometimes there are issues with discrimination, with retaliation. We're going to discuss what you need to know. A couple of topics, several cases. One was about a sandwich shop employee who had some problems with non-compete. Another about a baker who had issues about not wanting to make a wedding cake. So essentially, these things started with various contracts. David, give us a little bit of a background here. As it applies to employment anyway, what is a contract? What's the work contract?
So an employment contract is entered into by the employer and the employee. Generally, you don't have an employment contract unless you're a higher level employee, manager, ownership type of thing, something where the loss of you from the business is going to create a problem for that business. So entering into a contract, you would hope that you have some arm's length ability to transact the agreement in terms of negotiating leverage. But oftentimes, if you're just an employee of a business, terms can get dictated to you, and the courts will take a very close look at those terms to make sure that they're fair and reasonable.
So what is fair and reasonable? I understand that if you're upper level management, you have access to maybe proprietary information, and someone doesn't want you, your employer doesn't want you to walk out the door with the client list or the information. What's reasonable?
So it again depends on the situation. For a non-compete clause in an employment agreement, and that's just one clause of the agreement, for that to be considered reasonable, the court will look at how long a period of time you're being affected, what the geographical area that's being affected, and what the limitations on what you can do are. And for all of those things to be considered reasonable, the court wants to make sure that you're using the least restrictive amount of time, area, and perhaps the scope of the agreement. So, for example, I represented somebody who was a very high up at a very large pharmaceutical company. And they were in a very specific area of that pharmaceutical world, which was internet sales, not the drugstores and the retail spot, but the internet sales and mail order sales. So they had a 3-year worldwide restriction and for anything to do with sales online. So the issue in that was, well, is the 3 years reasonable? Probably is. Worldwide, is that reasonable? Well, now it's sort of interesting because we're talking about internet and mail orders, and if in fact the employer did operate worldwide on that level, then it may have been reasonable. But the third area, anything to do with mail order or internet sales, may not have been reasonable because there are areas that the employer did not operate in. So if my client was going, for example, to mail orders specifically to nursing homes and covering prescriptions to nursing homes for the patients of the nursing home, the residents, then if the company he worked for didn't cover those types of things and had no intention of going into that area, then perhaps that restriction shouldn't apply. And so the courts will look at the facts on an individual basis of each contract.
It certainly makes sense that they should, and I understand that at some of these higher levels, often when there's a non-compete that the employee signs on and agrees to, if there's that separation, that the employer will often offer to that employee some consideration, some remuneration for his not working for, what did you say, 2 or 3 years or whatever. These cases that have come up lately, they're referring to as the more vulnerable people. It was Jimmy John's is one franchise, but most recently the Subway shop. A Subway shop employee making less than, as they say, less than $15 an hour. And if he is no longer working for that Subway shop, apparently there have been suits that indicate that that former employee can't go down the street to work for another Subway shop. Well, it can't be a matter of what the special sauce recipe is, because there's certainly the same sauce recipe. There's an issue about the franchisee, I guess, being in conflict with another franchisee. How can they possibly restrict this man who's a lower wage earner from making other sandwiches for Walt's roast beef, for that matter, or Arby's or whatever, in another Subway shop? How can that hold up?
So that's an interesting question, and I think the courts would look at a couple of things there. Were the two parties entering into the contract on a level playing field when that contract was entered into? And from what you're describing, you would assume that they were not, that it was either you sign this or you don't get the job. That's not really an arm's length transaction. The second thing the court could look at is whether or not the restriction is reasonable, as we talked about in the other case, and geographically. So let's just say that this was, make the best case scenario you could for the employer, that this was the best sandwich maker in the area. And he had a following, and people were really loyal to this person. So after a period of time, the employer said, I really want to lock this guy up, so that's why we're entering into this agreement, so he won't go somewhere else and take all of these customers who come here to another shop, because he is the best sandwich maker in the system. So that might be a reasonable ground to do it, but what is the employee getting in exchange for entering into that contract? And if there is no consideration other than continued employment, then one might argue that it's not a contract at all, because there's no consideration given for the agreement being entered into, and a contract requires consideration. So what's the consideration that the employee is giving up? Is he saying, to maintain my job, that's the consideration? I think a court would not look too favorably on that. And then the third scenario to look at, or the third issue, is how far. Because how far is a customer going to travel to go to see the world's greatest sandwich maker? Is a mile reasonable? 2 miles? 5 miles? Because as good as he might be, I don't know that someone's going to travel 5 miles, independent if this was New York City, or I don't remember if that's what you said, but if it were, I don't think anyone's traveling 5 miles in New York City to get to the same Subway shop that they could have gotten to much closer to where they are in order to have this person make their sandwich.
Makes sense. These are good points for people to consider. When they talk about reasonable restraint of time and place, if we talk about the Rhode Island and perhaps even some part of the Massachusetts, southeastern Mass area, 3 miles might not be too far for someone to go for another Subway shop or whatever, but certainly when you referred to at the top of the segment someone who's in a higher echelon, then it's a matter of, if it's internet and it's global, maybe they do have more reason to have a wider field geographically within which to pose some restraints.
It really depends on the facts specific to the case. We had a case once where a fellow worked for a heating and air conditioning company, high-end salesman for that company, did a very good job, and there was a non-compete clause for parts of Massachusetts and Rhode Island. And if the company wanted to enforce it for all of Massachusetts and all of Rhode Island, and they only did business in a couple of counties in Massachusetts and Rhode Island, then if he was going to work in counties that were not part of the area where they do business, then it wouldn't be reasonable to enforce it in those areas. they could argue that, well, we intend to go there, but there has to be some real efforts to show that you are doing work, groundwork to do business in those areas. I think an advertisement in the yellow pages in the county where Springfield is, for example, if all your business has always been done in Rhode Island and Bristol County and areas close to that in Massachusetts, really is just grass match straws, and that in fact is what the court looked at and found when they didn't enforce the agreement for where the client was now going to work.
Sounds right. It's interesting, well, as we talk about this, and I'm talking about the sandwich shop, and you mentioned someone who's in pharmaceuticals. Apparently, across the board, 25% of the country have had people who are working who've been in a position where they had to have a non-compete agreement signed, which seems kind of significant. And apparently it's such a big issue with workers who are considered the more vulnerable, the lower wage. And I guess now it's such a big deal that Congress is getting involved with it across the various states, trying to deal with what's called a MOVE Act, the Mobility and Opportunity for Vulnerable Workers, because an awful lot of lower wage workers are falling victim to this, and they either lack the will, the money, the resources, the know-how to oppose the employer who's putting a burdensome restraint exactly on them. So for the lower wage earner, what would you say to someone when he goes to take a job and someone says, we want you to sign this non-compete and we're not going to pay you any more? Wouldn't that worker want to go to someplace else where he's not going to have a non-compete clause and maybe even more money? How do you deal with the employee in that case, David?
Well, there's a couple of things. First of all, before I'd sign anything, I'd say I want to bring it to an attorney.
Even the low-wage earner?
Even the low-wage earner.
Okay.
And I'd want to at least have a consultation with the attorney to find out, what is this? Is it reasonable? Is it enforceable? And those types of things. As far as Congress getting involved, you would tend to hope, and I understand it's the low-wage earner may not have the financial capacity to follow these types of things through a court system, but some of these things are best left to the courts, not to legislation, because there may be a legitimate reason for having somebody sign a non-compete clause. For example, even if you're not a high-wage earner, but you're working in an industry that requires you to have knowledge of certain specific processes, as you call them, or recipes if it's for a restaurant, or other things that are proprietary to that business, and now you know these things, the business has a right to protect itself against your using their information, whether it's a process or whatever it is that they've developed. And customer lists, for example, if you have access to a customer list and you can take that with you, they need to protect themselves, even though the law says that you can't take that stuff, and maybe you don't even need a contract to protect it. A contract gives the employer some added security. However, if it's really just sort of a punitive type of thing that the employer wants to be able to hang over someone's head if they want to leave and they don't want them to leave, and to try to have some hold that they don't otherwise aren't otherwise entitled to have, then the courts wouldn't enforce that. But I suppose what Congress is looking at is saying, is it really fair to require that lower wage earner to have to spend money to go and have his rights enforced in court?
Apparently that is what it is. And yet there are some states, I think Alabama is one of them, that seems to be a little bit more progressive in terms of trying to help protect those vulnerable individuals. And especially since some of those lower wage workers look to have maybe an extra 25 cents, 50 cents, $1 an hour more, and if it is across the street, they want to be able to go to take a better job. You would think that it would be worth it for that little sandwich shop owner to pay them a little more, give them a little more management experience, or help move them along. That certainly would be seeming like a better solution all around.
And some of what you might be able to negotiate in your agreement, if they want you to sign an agreement that restricts your movement from that job, is some consideration. And what form might that take? Okay, you want me to sign this for 3 years? What is my raise going to be each year? Because I'll negotiate a raise right now because I want something in return for signing on for 3 years. So I can protect myself against the guy next door offering me $2 an hour more or whatever it might be by saying, you give that to me in a contract now. You want a contract? You want some protection? I want some protection. And that's reasonable.
Very helpful information. We always hear about the protectable interests on the part of the employer. Thanks for giving them, the employee, some protectable ways of taking care of himself, too. A little bit about, was the Newark, New Jersey Housing Authority. A woman realized in her position that they were not doing business the way they should and not putting work out to bid as they should. Long story short, she blows the whistle and now is ending up in a court battle with the housing authority because she now is being harassed a little bit. She's been passed over by other employees who are her junior and whatnot. So it seems, as she says, I've had undue stress, needing doctor's supervision. I'm being retaliated against. What does an employee do when she's a whistleblower and then suddenly is suffering some consequences?
There are whistleblower statutes in most states, and I think there may even be a federal form of that, depending on if you're in government work and that type of thing. So there's protection in those acts, and every state, it's written slightly differently, but she has rights under the act, so that this lawsuit that you're describing is probably her suing her employer for the treatment she's getting as a result of having acted in accordance with that statute.
Yes.
So she probably has a very good claim against them. If they have held her back from promotions that she's otherwise entitled to, there may be attorney's fees and punitive damages and other things that are includable in the statute. It depends what state it is and what the statute says.
Good. And of course, as I always hear you say, in just about every case that we tackle, make sure you've documented the thing. So hopefully this worker has done that so that she has good support for her case.
Both the damages, which are the incidents where she has been either harassed or passed over or not treated fairly, and the information on the issue that she blew the whistle on.
Yes, the bosses did wrong, what they did wrong. So let's go across the pond a little bit. Apparently in Northern Ireland, a baker was found guilty of discrimination over gay marriage cake. So bakers take contracts all the time. I'm having a bar mitzvah, I'm having a wedding. Suddenly this baker says, I'm not going to do this cake for you because he did not want to have the Sesame Street gay logo on the cake. Apparently, when there's been a landmark ruling, at least in Northern Ireland, about this, that the baker discriminated. Is there a contract if some baker says, I don't want to do business with you? Where's the contract point, David?
So I can't tell you what the law is in Ireland. But
fair enough.
We'll move the case here.
Fair enough.
There are a lot of things that you can do. And I'm not going to use the word get away with, but I can't think of another one. But for example, if you are an employer and you let somebody go without any reason, you can do that probably because we're an at-will employment state. You're not required to employ somebody. But if you fire someone and say, I'm firing you because, and then you name one of the issues that would be otherwise protected in a discrimination case, then you can be sued for that. So if the baker is approached and said, I want you to do this cake, and he says, yeah, I can do that cake, but I'm not going to do that cake because that is the gay symbol or whatever it is, and I don't want to do that because I don't think that's right, he can probably be sued for that because it's discrimination. If the baker simply said, no, I can't, I don't know how to do that, I can't do that, he could probably not do that.
He could also say, I'm too busy, I'm sick, I'm whatever else.
Yeah, but if you discriminate and you actively discriminate, then you are and should be subject to a lawsuit and the punishments and fines and costs that go along with it.
So this case really did come down to his being found guilty because of the discrimination, not because of their not because it was a breach of contract.
Right.
But if he, the baker is approached to do a wedding cake, And usually what happens is, okay, your wedding is thus and such a date, you sign on the dotted line, you have to put a deposit in for 50% or whatever their arrangement is, and then, well, I'm not sure of our colors yet, I'll get back to you 3 days, 1 month later or something. So now they come back and say, I want the Sesame Street characters, and I don't know if it was Bert and Ernie, I don't know who they are, honestly, but now the baker has already had the 50% deposit, and he realizes that there's a gay couple that's going to be on the wedding cake, and now he says, I'm sorry, it's against my religious beliefs. Well,
So
that's discrimination, but isn't it also a breach of contract at that point, too?
It is a breach of contract, unless there was something in the contract that restricts the types of things the baker has to do. Then if the contract says that you're going to do the cake and we're free to give you the design, and whatever design we choose, you're going to be able to at least try to do, then the baker has not only discriminated in that case, but he's also breached the contract, so you could sue him for both the breach of the contract and any consequential damages that you could get as a result of that. And if you want to go back to the law school days, it's Hadley versus Baxendale, an Old English case that laid out consequential damages in a contract as long as what the damages are reasonably foreseeable. So that if it's reasonably foreseeable that now they have to go out and get the same cake from somebody else at 3 times the price, not only do you have to then pay as the breacher of the contract the money that you took as a deposit, but the difference in what they would have had to pay to get the same cake done.
Do you also get, as consequences, undue stress and a wedding is a stressful situation anyway, never mind someone balking at the last minute and being unwilling to make your cake. Do you get those kinds of damages
Generally in damages in contracts, that's not one of the damages that you would usually get.
Okay, fair enough. In this country, never mind in Ireland, we had recently the issues about Holly Hobby not wanting to do things. It was against their deeply held religious beliefs, and it was a different issue. Can employers today in this country say that it is something is against their religion? Is that a bona fide issue for them to take up with would-be sales?
I guess we've seen cases on both sides of that issue, and cases that have said that they can't be required to provide certain health care things, and cases that say that they are required to do certain things. And frankly, if you do business in the public, and this really goes back to the very beginning of enforcement of civil rights in the 60s, and I think it was when Robert Kennedy was the Attorney General, the cases being brought in after, using the Federal Commerce Clause as protection, saying if you do business in interstate commerce, then you have to follow these federal civil rights laws. And I think there was a case called the Heart of Atlanta Hotel that was discriminating, not allowing African Americans to stay there. And they were found to have violated the law because they were impacting interstate commerce. And so there are some creative ways of enforcing the law, but discrimination is discrimination, and most businesses would be hard-pressed to get away with that.
Businesses. And now, in Ireland, they were referring to the fact that this was a business, and it certainly was not a religious organization. So in this side of the pond, if someone says that we are a religious organization, I don't know, whatever that might, do they end up getting a pass on doing something like that for that reason?
I think a religious organization would have a bona fide argument as to certain things that affect them and what they have to do. So I think that's a fair and reasonable interpretation, but we're going to have to stop you from going on trips to Ireland.
I guess so. I guess so. And while this is a slightly different issue, not about employment, but about contracts, so many people are shopping today on the internet, and quickly, when you think about when you are buying something online, after you've bought it, put your credit card in, there is the rest of the story. The rest of the story could be 20 pages in 3-point mouse type, 3-point font, that tells you all the things that can and can't happen as a result of you buying something and then not being happy with it. that's a contract. Is that contract law, and we have to read all of those 20 pages of mouse print before we decide whether or not it's actually a thing that we want to get involved with and purchase?
It very well may be, but it also may be what we would call an adhesion contract, which is a contract that has all, in the old days, that small print on the back side of the contract you're signing that nobody ever read.
Yes.
And whether or not it's enforceable would really go back to whether or not it's reasonable.
Reasonable. So comment on this part. Is this reasonable, David? Many will say when you are either returning something that you weren't happy with, whether you didn't like it, it didn't fit, poor performance, or whatever it is, that you have to submit to or you have to agree to arbitration. Is that worthwhile for someone to say that that's a worthwhile thing? Is that a reasonable thing for a vendor to make you sign off on versus trying to sue them for whatever?
So again, I think it depends on how much arm's length bargaining power you have, because a lot of times these things are not even negotiable and therefore may not even be enforceable. The agreements that require arbitration in Texas and you're in Rhode Island may or may not be enforceable depending on the circumstances and the facts. But if it's, you know, a purchase over the internet that's of little value or whatever, it's not like a major type of dollar figure, it's probably not worth trying to get that stricken from an agreement. But if you're buying a multi-million-dollar type of thing, then you may have some bargaining power, and you may be able to get that clause that says you have to arbitrate in the home state of wherever the person you're buying from is, and say, no, I'm not willing to do that. And if it's such a big item, they might be willing to negotiate with you and say, okay, we'll agree to Rhode Island if you're buying it in Rhode Island, because they want to get the sale.
Of course, this would have presupposed that someone did read that 40 pages of mouse print, and these days, considering everything from cars and boats to homes and whatever at a higher price than, you know, a $20 item, it certainly indicates that there may be more reason for someone to look at that clause about refunds and returns at the very least, and not something that I guess from what I've been reading the average consumer pays attention to, but perhaps they should.
Yeah, and I would imagine, my guess, that 9 out of 10 people, I think I might be even low on that, 9.5 out of 10 people, where it says click the box that you agree to all these terms, don't read it. They just click the box.
Exactly. That's one of the reasons why I wanted to bring this up, as I've seen that there have been more cases online that have been showing up in this particular issue. So, thank you, David. We hope that this has been helpful to you, and we hope that you don't have problems with your employer or employee, but if you do, we hope that this has given you some additional insights and things to think about. We invite your questions and suggestions. This is The Law Matters. Stay tuned, because the law matters to you.